thinking of rolling out biometric time clocks. Wondering, should they no longer do so? Do either of you have thoughts on that, on the biometric time clocks?
Sure. So what I would say is, again, BIPA does not preclude the use of biometric time clocks or any other technology that implicates biometrics. And instead, it just wants the entities that are using biometric time clocks or other similar devices to make sure the people who are using it have notice and they give their consent before turning over the information, et cetera. There are a lot of advantages to using a biometric time clock because of how precise they are for both employees and employers. They tend to be very popular. So I wouldn't say you necessarily should no longer do so because of BIPA. It's more evaluating whether the benefits of a biometric time clock are significant enough that it's worth implementing the BIPA notice and compliance processes, which again are not particularly onerous. So I think the benefits of biometric time clock can be captured even if it means going through the various procedural hoops of BIPA.
Excellent. Thank you so much. Sylvia, any thoughts on that before I go to the next question?
No, I think Greg has largely addressed that. Again, I think it's a matter of just being sure that you are complying with the requirements of BIPA.
Excellent. Now, a question also coming in. Would you recommend creating a nationwide BIPA policy that would comply with Illinois and other jurisdictions? What are your thoughts on that, on the nationwide BIPA policy?
I'd like to take that one, Elizabeth. And, it's generally, we generally tell our employers that, to the extent that they can create a policy that addresses a specific jurisdiction, that is preferred. And obviously, we have employers who would prefer to have just one policy, especially if they have multiple operations out of multiple jurisdictions, and it's more feasible and more efficient for them to do so. In that case, as we discussed in our presentation, BIPA is the most stringent statute out there that describes very specific requirements that an employer has to follow in order to comply with the statute. And as Greg and I both discussed in this presentation, those requirements also include the written notice, receiving informed written consent from the individual, as well as developing a public policy that contains the retention as well as the company's destruction policy. And I think more importantly than just having a policy that includes all these requirements, it's also important that companies consider how they will comply with these requirements. Certainly, the employers will also want to keep in mind the ever-changing landscape that we discussed both in California as well as some other bills that are pending in New York City. As we're watching what's happening in California and other states, we do foresee, based on what's happening here in Illinois, that other states will mimic and mirror a lot of what the legislator has done here in Illinois. And so, going back to the initial question, do we recommend creating nationwide BIPA policy? I think it's important to make sure that whatever policy you use does in fact comply with the Illinois statute.
Wonderful. Thank you so much. I want to get to a few more questions. First, though, attendees, it's not too late for you to get a question into us. Again, just utilize that chat window. And before we move on to a couple of more questions, that next word for those surveys coming to you, again, if you're applying for continuing education credit completions are mandatory. That final word to fill in is plaintiff, P-L-A-I-N-T-I-F-F, plaintiff. That final word to fill into those surveys. So another question, and I know that this was covered a bit in the presentation. If we could drill down just a little bit more in this example coming in. I was served with a class action BIPA lawsuit, but we have a BIPA policy in place and obtained a written release from our employees. What should we do?
So the first step would be to figure out whether the individual bringing the lawsuit or individuals bringing the lawsuit have already signed the release got notice, etc. And if that's happened, and that happened before their biometrics were collected, alleged biometrics were collected, I should say. So, for example, if that happened on the day they started work and then they didn't use the time clock until after doing so, that definitely should be brought to the attention of the other side's attorney. And I personally had a situation where that exact situation happened, where it turned out the individual didn't remember that he filled out a BIPA consent form, which is understandable because it was part of, the onboarding process. But when we demonstrated to his attorney that he signed the form and he did so before using a time clock, the attorney agreed to drop the case. So that was an ideal scenario where the person got the release before ever giving their biometrics. But if that's happened, yeah, you could try to cut off at a pass because attorneys, there's so many of these cases, hundreds of these cases. They're not going to want to spend time on what could be a sure loser. So that's how I would proceed.
Excellent. Thank you so much. I think we have time for one more brief question before we close out. And again, this going back to the time clocks, are the vendors of time clocks or other technology the responsible party? Should we be addressing that in the vendor agreements or contracts?
So, the vendors of time clocks and other technology certainly will and have argued that they're not responsible. They supply a device, but using that device and complying with applicable law is something that the user has to ensure, not the person who provided the device. So even though these time clock vendors and others still could get drawn in, they're consistently arguing that they're too far removed from the notice and consent obligations just because they provide the technology. So certainly in vendor agreements and contracts, that's something to consider spelling out, from both sides. What if there is some sort of BIPA violation alleged? What are the indemnification obligations, if any? What are the notice obligations, if any? What limitations of liability are there, if any, et cetera? Because if court does it, if you're an employer, for example, and a court is not willing to hold a time clock vendor liable, then absent potentially something in an agreement that provides for it, it may not be possible for the employer to do anything with respect to the time clock vendors. And the other side of the coin, if you're a vendor of these technologies, that's something you want to spell out in your agreements as well.